Yo, yo, yo. What it do, what it don't do. It's your boy Cinco Band's the man. Trying to get 100 grand. You know I got the plan. Man, we bike. Yes, sir. We bike. We are back with another one. Most Valuable Podcast, episode 78. We are bike. Yes, sir. And today we got that boy YMW Melly on the. We got YMW Melly. We about to see what he talking about. Hey, shout out to everybody on their way to work, on their way to school, on their way to their little, yeah, you feel me? Cheers to you guys. We here, we active, we back, you know what I'm saying? We just trying to keep it consistent, keep this content going, you know what I'm saying? That's really all that we trying to do. That's really all we trying to do. So, without further ado, we here for you and the rest of the YouTube world. I am the man Cinco Bands, and we about to get into this content. You dig?
The trial started tomorrow. And then that's September the 5th, 30.
Bro is not happy today.
I don't even understand what frequency you are. I mean, this is a death penalty.
And Judge, the heightened you.
No, now it's my turn to talk. So you all decided, for someone who's already facing capital charges, let's open up a new case. You could have done all this the day after his murder trial. You could have done all this.
Oh, YMW Melly appeared in court for motions and goes against the advice of his lawyers. Melly is seen snapping at his lawyers over the stay in the case. It seems Melly doesn't want any more delays himself, but his lawyers advised him to keep the stay on the case and delay the trial. The state wants to delay the trial as well. You're going to see what the judge does towards the end of this video. If this trial gets delayed, it wouldn't happen until 2027. That's what the judge says. Watch the full video, hit subscribe, let's go. Alright, stream cuts on late. Stuart Odyssey and Melly's lawyers already talking. And here's Mr. Griffiths from the state and the judge. Let's go.
29.
Hey, shout out to Cuff Boy. Y'all go follow his page. Hey, he been in there. How long Melly been in there? Melly been in there for some years. He done been in there for some years. And when I was in there fighting my case, they do put off time, and when they put your court date off, it's sometimes years. So, you know, it's a lot of months. Sometimes it's years. So in this instant, it seemed like they trying to push him back some years, a year and a half. You know, they say the court's dates are backed up. They have trials set and everything like that. So they try to back you up as much as possible. And they not giving him no bail. So they just want to keep him in that thing. You know what I'm saying? He hot. He mad. I wouldn't be happy either.
Mr. Demons voluntarily surrendered with 2 counts of first-degree murder. In October of 23,
I'm sorry, this guy's face right.
All right. Now's the time to hit that like, hit that subscribe.
The upcoming season of Love Island USA. What do you see?
let's take a look.
It's the boy Cinco Bands. You already know what it is. Now's the time to hit that like, hit that subscribe. So Melly already been in that thing for like 3 years now, going on 3 years, and they want to set it back for another year and a half. That's almost 5 they're trying to put on that young man. Crazy work, son.
Sorry, this guy's face right here.
Mr. Demons was rearrested for tampering with the witness, directing the activities of a criminal gang, solicitation to commit tampering, and conspiracy to commit tampering. As a result of that, the state provided supplemental discovery in the murder case and represented to the court on numerous occasions that the tampering case is intertwined with the murder case, and they expect to evidence of the tampering case to a certain extent for consciousness of guilt.
Yeah, we've known about that. They're trying to show Melly was trying to silence his girlfriend. Remember the whole coded language bullshit. He's guilty. He's trying to hide witnesses from the court. Blah blah blah. You get the picture.
A year transpired, and in December of 2024, the defense learned that a search warrant was executed on a member of the defense team's Apple account, Miss Liberties, and they withheld that evidence for over a year. And I would submit to the court that had not Apple notified Miss Liberty a year later that a warrant was executed, the state probably would have concealed that point as we stand here today.
Still crazy to me. We already know all this. Everything, the entire iCloud account was taken by the state of a lawyer.
And the court originally indicated that the state was to produce to the court the affidavit and the warrant. The following day, the court modified that and told the state to produce a copy of the warrant only to the court, and that the court would, in fact, do an in-camera inspection of that warrant and decide whether or not to reveal a portion of that search warrant or the total search warrant. On January 14th, before the court ruled on the warrant.
This is the same shit they've been saying for 3 years. This is the same shit they've been saying. They ain't changed up no script. They ain't added no new charges. This the same shit. So how they just keep holding them, postponing them. Man, when you fighting the death penalty, they do you like this, man. They'll dog you out. They'll have him sitting in there 10 years trying to go to court. I mean, a whole nother decade, a pass. These motherfuckers don't care about none of that, bro. And guess what? The crazy part is they getting paid by the day, by the motherfucking day for this man, by the meal, by the transportation, by the clothing. They getting paid in all different ways, by the canteen. They just getting paid. Paid. That prison shit, man, people was mad. I remember back in the day, people was mad. They found out Michael Jordan was investing in prisons. You know, because it's a systematic system that's meant to lock up his people, urban people. You know what I'm saying? So they was upset that he was a representative of the urban community and he was putting forth funds to help the correctional facilities. But when you look at it on the other side, man, that's a business that's never gonna stop businessing. It's never gonna stop rocking. Niggas gonna always go to jail. You feel me? But at the same time, it's fucked up, bruh. It's fucked up because they got you in there just stuck. Anything you do gonna add time. Then they prolonging you, stringing you along, trying to get more money off you. You know what I'm saying? It's just a cash cow. Total, all in all, I say they making probably close to 4-5 bands a day off Melly, and they didn't have him in for 3 years. Somebody do the math on that. That's crazy. It's fucking crazy.
The state filed a memorandum of law regarding attorney conflict, setting forth that regardless of if Mr. Demons wants to waive any potential conflict, the court must basically throw her off the case. And they cited various case law, and I agree with the state that the court does have the inherent responsibility or authority to remove an attorney based upon the nature of the conflict. I agree with that, and it's been done in state court and it's been done in federal court, so we're in agreement with that portion of it. As we sit here today, 18 months later from the execution of this warrant, Mr. Demons does not know the full extent of the conflict, nor do the lawyers know the extent of where this conflict exists, other than they executed a warrant on Miss Liberty's.
So it been 18 months only, that's it? Melly only been in jail for 18 months? It seems like, nah, that's not, hell no. Melly only been in jail for 18 months? Nah, hell no. It seemed like more like 3 years. It seemed like more like 3 years. Probably 18 months since they filed this new charge. I don't know.
Seems a bit unfair, right? I mean, this guy is facing the death penalty, and we don't know if one of his lawyers is going to be arrested at any moment, and the trial's in 2 months or 3 months.
In July of 2025, saying that she must get off this case. And if they really believe that, they should pursue that, because that would be the first issue on appeal if he's convicted of anything.
Damn, they're like, we're already going to appeal this shit. That's the first issue right there if he's convicted. I mean, we all know if Melly is found guilty, there's going to be some appeals, right? Like, there's going to be a whole big process, bro.
And I suggest that the court...
Big appeals.
If you really want to be a CEO...
Top of the morning, top of the day. You are now rocking with the most valuable podcast. I am your host with the most, coming straight from the West Coast, Cinco Bands, the man. Now's the time to hit that like, hit that subscribe if you rocking with us this morning. If it's your first time to the channel, welcome. Welcome. We all family in here, man. Gang, gang. Gang, 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 gang. Same thing, same thing.
That the court should hold a hearing on that and divulge the extent and what the conflict really is.
To the channel, please hit subscribe. I appreciate the support. Back to the video, boys.
For over a year, the state came into court and said it's an ongoing investigation. And as a result, they are allowed to conceal that, and it doesn't come under the discovery rules to provide that information. And the court in its order, in I think paragraph 4, stated, this court does not agree that the search warrant is part of an ongoing active investigation.
So they lied. The judge is calling them out that they lied. Remember that?
As of January of this year, Ms. Liberty has not been arrested, nor is she a defendant in any pending prosecution, despite the fact that the state has had this information for over a year. Well, they now have that information for over 18 months, a year and a half, and they're still alleging that it's an ongoing investigation. The interesting thing about Your Honor's order, everything was interesting, but you gave the state an opportunity to appeal Your Honor's ruling and said, I would not divulge the warrant.
And they didn't appeal it. You gave them a time frame, and I'm pretty sure they did not appeal it.
You have until February 7th, 2025 to appeal the finding of this court that this is not an ongoing investigation. They did not take an appeal. And I suggest to the court that the law in this case as we stand here today is that there is no ongoing investigation as it relates to anybody in the defense team.
There's first look at Melly. That boy's smiling, like always, looking over at his family.
A continuing obligation to disclose any information that would lead to relevant information. They have not disclosed the affidavit. They stand here today and say it's still an ongoing investigation.
Raven Liberty and his mom have not spoken. They're not on good terms, so that's pretty awkward.
And one of the definitions is it's something that will occur soon, at a time that is not long from now. They've had 18 months to sit on this, and they've done nothing except come in here and conceal this to the defense. I don't understand that. If they say it's foreseeable, when? When are they going to take action? 18 months is a long time for us to sit here and worry about what's going on. Now, I do thank the state for citing the Hill case in their memorandum, their addendum, because in the Hill case, they said the appellate court said that the court was right in not disclosing the affidavit because the charges of Mr. Hill were different than the charges that were based on the search warrant. And they said it would not lead to any fruitful or relevant information. The search warrant in this case, tampering with a witness on a capital felony and directing the activities of a criminal gang, which is exactly the same charges that Mr. Devins faces in the tampering case, and which they come into court every time we're here, and it's brought up, saying we're going to use some of that evidence in the murder case. They can't have their cake and eat it too, Judge. As we have said, this case is different from most cases because death is different. If Mr. Devins is found guilty of these charges, he's looking at the ultimate penalty of death. The rules provide that they have a continuing obligation to disclose all information that could lead to relevant information in a timely basis. As we sit here today, we're 2 months away from trial. We've waited 18 months for them to disclose it. We attempted to bring in Detective Luna.
Detective Luna was the detective that, on a deposition, she refused to answer questions, and Mr. Griffiths, the one standing right there, stopped this detective from answering questions with the ongoing investigation and said the judge was wrong. Sheriff.
We got Lexi Barnes rocking with us this morning. Shout out to you, Lexi. On your way to work, queen, on your way to your job, on your way to your look. Yeah.
Said the judge is wrong. There is an ongoing investigation. We're not answering questions in this deposition about that.
Despite Your Honor holding, this does not qualify under the statute as an ongoing investigation. They said this, Your Honor was wrong, period. Now, I got to tell you, that takes guts, in my opinion. That takes a hell of a lot of guts for a lawyer to come in here when they had an opportunity to take this up to the higher court and say you were wrong and do nothing, absolutely nothing, except impede our investigation to properly prepare for trial.
I used to have a big, ugly brown wallet that would take up so much space in my pocket and would always fall out. But over 6 years ago, I got sponsored by Ridge, and I've never used another wallet since. And I haven't been sponsored by them in years.
All right.
I'm telling you, boys, even without being sponsored, I continue to use it. Thank guys, back to the rest of the.
The 23 case, the tampering case, which Mr. Demons is quick finish.
Let me guess. You're thinking about going to therapy. And as a therapist myself, of course I'm going to say that's a great idea. But first, let's talk about the things they don't tell you. First of all,
which Mr. Demons and his quick finish are charged with, has nothing to do with the Apple iCloud investigation. I believe we even said in court that anything that came out as a result of that iCloud investigation would not be used in his homicide trial. I think we made that very clear to the court. They're completely separate entities. So the fact that they're imputing what's happening in the 23 case and we intend to use that in trial and we filed a motion, that remains true. But that investigation has nothing to do with this. This is actually a separate investigation stemming out of a separate incident. The court twice previously has refused to turn over the affidavit, meaning the court has refused to let the defendant and his counsel know the nature of the investigation. I stand before this court today, it is still an open investigation, which is why I filed a motion for an in-camera hearing. Because the court also pointed out last time when we were here that you had not taken any testimony, and so the only decision that you can make that whether it was an open investigation or closed was the fact that only time had passed. I included in my motion the fact that there is case law that states that there is no time limitation on how long an investigation can take. They take as long as they take. I'm sure the court's aware that investigations involving like embezzlement and other crimes take longer other than a simple delivery case. I still take that same position I've taken before, which is outlined in my motion, that they have brought forth no new facts, no new issues, whereas the court has previously denied this issue, denied them the affidavit, denied them knowing what is going on with this open investigation. And so they bring nothing forward to the court today, so really the order of the court stands, which is they're not entitled to it. We again are prepared to take that next step, do the in-camera review, so the court can have an insight into the nature and the state of this investigation. We didn't feel that a hearing or an in-camera review to make that determination was necessary.
Y'all hear this dude? So they just want to keep stringing him on. They want the court to let them keep stringing him on. They basically sitting here saying, yeah, it's been 18 months and we're still investigating. I ain't the sharpest knife in the drawer. But I don't know how long an investigation that ain't got nothing to do with no murders or no nothing. What are they investigating his lawyer for this long? I think they want to keep that fire under her ass and keep that pressure on them throughout this trial. Have her worrying about a case in the back of her mind so she can't really focus on Melly case. You know what I'm saying? And they want the court to allow them to continue to do this. Yeah, okay, we understand that it's no time limit that's specifically noted down for an investigation. But bruh, what the fuck are you investigating for 18 months? That ain't a murder. Fucking embezzlement.
The court already ruled on it, and we've simply provided the court with a memorandum of law. So at this point, they provided nothing new to establish why they need to know the nature of this investigation and where it is and what's ongoing with it. I understand everybody's frustration, it's taking a long time, but the case law allows for that. So where they are now is they have access to the warrant. We're in a similar position, just like the Hill case, where we dealt with a confidential informant in an ongoing investigation, and the court, even without conducting an in-camera hearing, said, because this doesn't deal with anything related to the affidavit, there's no need to conduct it. He's charged with something separate. Mr. Demons is charged with something separate. And so candidly, there's no point for even an in-camera hearing. It just needs to be denied outright. But we're still prepared to do that in-camera hearing.
So you're saying none of this is necessary. It's a completely separate investigation. We're not going to use anything that was found on Raven Liberty's phone or anything in the murder trial. This whole thing is just, I still can't believe this is just taking this long. This trial just needs to come. And I hope to God he's not delay this trial, because that's what the state wants, by the way. They want to delay this trial.
The state's position and why we have been at this point during the previous court hearings.
Is Detective Luna and a witness in the murder?
She was not listed originally. What we didn't know actually came out during the depo is that she was a training officer when Mr. Henry brought the bodies to the hospital, and one of her associates actually ended up writing the report. She didn't write any reports. We actually didn't even know she was on scene until she came into the depot and informed us she was there.
Yeah, that's something we all found out. When I read the deposition, I was like, wait, what? She was at the hospital when Bortland dropped off the bodies?
She didn't take any active role in it, but she was a supervisor, or she was the FTO for one of the officers. And I think at that point we listed her as an A witness because we realized she was on scene. The fact that she doesn't have anything material in terms of the homicide case, we theoretically could change her back to a C witness.
As we're having this hearing, she's an a witness in the murder.
Yes.
Next question. She's an a witness in the tampering case?
In the 23 case, no.
She's not.
No. Yes?
Well, hold on.
Oh my God, which one is it? Griffiths is saying no, she's not a witness in his witness tampering case. And then the other state attorney behind him goes, wait. And now the judge is picking up on it. Is she a witness or not in the 2023 case?
You're the one that listed your witnesses are, so is she a witness in the 23 case?
No, Your Honor.
She's not.
She's only a witness in the case because, as I explained to the court, we didn't realize that she was on scene.
Oh my God.
Apparently she was listed as an A in both. We're going to remove her from the 23 case
I'm
because
looking right now. She's an a witness.
she is, appears to be listed in error. She had nothing to do with the 23 case.
She was defiant of the search warrant.
That search warrant has nothing to do with the 23 case.
Hold on. One voice at a time. Didn't you turn over this? I ordered you to turn over.
I'm sorry, Judge. She's not listed in the 23
I understand the parameters of both arguments, okay? I have no control of the law enforcement's continuing investigation. That's not even my purview. What my purview is the heightened process that's required to murder death penalty, all right? This witness, Detective Luna, WNA is listed as an A. It doesn't matter to me what's going to happen if the state changes their mind because they don't like the results of the hearing. But she's like any other witness. She has no right to refuse to answer any question.
As to an open investigation, she does. That's the state's position. She can discuss.
Yikes. He's saying because she's an A witness, she has to answer questions at a deposition. And he's saying, I don't agree with you.
She's like any other A witness. She has no.
Wait. The judge is telling him something, and he telling the judge, no, she does. How can you tell the judge what the fuck is gonna happen in his court? The DAs, they some bold motherfuckers. You hear me? They know that they tied in with the supervisors and the superintendents and the Congress and all this shit that fucks with these judges. They know all these judges, backgrounds, family stories, all this shit about these judges. And they come in there like, yeah, you control the court, but I know your secrets. You ain't just gonna throw your weight at me. But he can, and he needs to, because what they doing, that's just not cool.
Right to refuse to answer any question.
As to an open investigation, she does. That's the state's position. She can discuss.
Yikes. He's saying because she's an A witness, she has to answer questions at a deposition. And he's saying, I don't agree with you.
She's like any other A witness. She has no right to refuse to answer any question.
As to an open investigation.
Need better internet? Get Cox Internet for $40 a month when you add.
Now's the time to hit that like, hit that subscribe. You are rocking with the best, the most valuable podcast. Yes.
She does. That's the state's position. She can discuss. Well, then I would ask the court to conduct the in-camera hearing.
So with all due respect, I don't have to. I mean,
Actually, I believe under 3.22, I think the rule says the court needs to.
I probably should choose my words carefully here, but I don't even understand what frequency you are. I mean, this is a death penalty.
And Judge, the heightened
No, now it's my turn to talk. The whole purpose of this is for him to decide, and by the way, I believe I said this back there, there is a conflict, obviously. And they don't agree with the law. I don't get to decide who Mr. Denton's lawyer is. Mr. Denton gets to decide who Mr. Denton's lawyer is. If one of Mr. Denton's lawyers is not following the professional rules as required by the Florida bar, that would be an issue between that person and the Florida bar. As far as a death penalty case, based on all of the very current Florida Supreme Court case law that I have cited on multiple occasions, it's his decision, because even if there's a conflict, if he says, Judge, I want her to be my lawyer, she gets to be the lawyer. And if he says, Judge, I don't want her to be my lawyer, then she's not going to be my lawyer. That's why I had a discussion with him about this back in February. That's his decision. The reason that I have all these, the search warrant, the results of what they got from the search warrant turned over, none of this should be new information. It's all coming from Ms. Liberty. At least that's what's been represented to me, so she knows. So she can sit down with her client and tell her what's in it and decide. So to that extent, the entire purpose of all of this was to make sure Mr. Demons had the correct material in front of him to make it. He still has to make it. His time to do so is rapidly disappearing at this point. But the bottom line is, this is an easy call today because she's made moves. So we need to send the answer questions. That's it.
Boom. Griffiths is like,
So they let him. So the judge agreed.
I ordered 200 hand-forged knives to my dorm room.
The judge agreed with Melly team, so that was a win for the defense in that sense. But we're gonna see what else happens.
Griffiths is like, well, I disagree. It's an open investigation. She doesn't have to answer the questions. Judge saying, fuck no, yes, she does. She does have to answer questions. Shooting that down.
Respectfully, over the state's objections, over the state's cited case law, over everything. You charge him with a crime. He's an witness. She has to come to that point and answer questions just like any other witness. So your motion compels grant. Just answer whatever questions you want. So I'll enter a separate order regarding that.
Motion to compel is granted.
So you're all going to be fighting about 250 jurors are lining up outside the door there. So
Just so I can
use your time. And that's how you're going to
So just so I can.
You're all going to be fighting over this as 250 jurors are going to be lining up out of the door. I'm surprised it's not like 500 jurors. It's going to be pretty hard to find people in Florida that don't know about this case.
Should the court say, no, we're not turning over the affidavit, but we're taking the deposition of Detective Luna, which concerns materials contained in that affidavit, the court's not ordering it turned over, in the state's view, she can still refuse to answer those questions because it will go through that ongoing investigation.
I'm sorry. I understand what your position is. Listen, who decided to charge him with tampering? Who did that?
The 23?
Did you do that?
Yes, Judge. No, I mean, no, but I understand where the court's going with law enforcement. Yes.
And the state did that.
Yes.
So you all decided, for someone who's already facing capital charges, let's open up a new case. Let's charge him with a new crime, which can lay him in prison for the rest of his life, by the way. So you're confined to the rules of discovery. I don't know what to tell you. You could have done all this the day after his murder trial was over. You could have done all this.
Boom. They didn't have to do this if you think about it. Because then they're bound by the rules of discovery and they have to give over everything. They can't be hiding shit.
You do it when you chose to do it, so be it.
No, not the 20, so the court's clear, for the record, the 23 case has nothing to do with this Apple iCloud affidavit or with what Detective Luna potentially testified to in terms of her work in this new investigation. They have nothing to do with each other.
Sir, if a law enforcement officer hypothetically showed up at my door asking to serve a search warrant on anything that belonged to any lawyer who's currently litigating a death penalty case, I would decline that request and probably ask them to leave the courthouse. Okay, so that's just my view.
Oh, he said I would have not wrote that search warrant if I was the judge. I wouldn't have given him the search warrant that's a lawyer or in a death penalty case. So he's kind of shitting on the judge that signed that warrant.
States, anything else that you want to tell me in support of your motion?
No, Judge, my motion basically covers the previous court's orders, the statute, the case law in terms of how
This is legitimate.
this case is stayed.
Okay. Defense, do you all want the case to be stayed? The state says it's stayed, so should you agree with their motion?
Can we have 1 moment?
Sure.
So state wants the stay to stay in place because of the whole appeal nonsense. They're trying to delay the trial. The state doesn't want to go to trial in September. So that's what's happening here.
Yeah, it looks like they're trying to delay. He needed speedy. He like, I want a speedy, nigga. I done already had a mistrial. Y'all trying to hold me, nigga? Nah, speedy trial, nigga. Look at him.
He seems angry, right? He was snapping at them.
He like, I don't want them to see me have too much anger in here. But stop playing with me,
Yes,
bitch.
sir.
Do not.
Against our advice, our client wants to proceed.
So you object to their request for me to determine if it's automatic stay.
Based upon what our client has instructed us, yes, sir.
What?
Shout out to Melly! Excuse me, I'm yelling this shit. I'm sorry. Hey. That's a W for Melly, man. His lawyers didn't like it, but fuck it. Y'all not finna keep stringing me. Let's do this. Let's get in the ring.
Melly's going against the advice of his lawyers. He's objecting to the stay. His lawyers didn't want to object to it.
I am aware that 924-071 calls for an automatic stay while the state is appealing some orders they want to appeal.
they were aggravators. They go to membership in a gang. There were things that the jury would have to find before going into penalty.
Not aggravators as to the death penalty, aggravators as to the gang enhancement itself, Your Honor. That was charged. He was charged in committing the murder for the purpose of the gang, which is an aggravator in terms of the guilt.
Something that they would have to find by way of an interrogatory.
Yes.
The aggravators with the whole gang bullshit. I've said this over and over. If Melly killed them, this has nothing to do with any gang. The gang is just an aggravator they wanted to add in for the death penalty.
No, objection, that's not true.
That's not correct.
So you all don't agree on that?
No, we don't.
No, what you just said, we do not agree on. There is,
I'm sorry. Have you all done what Judge Murphy ordered you to do?
So Judge Fine, or whatever, in 23 ordered them to figure out what evidence falls under the suppression order. And apparently they haven't done
the
it.
state appealed it all, which stayed everything. And so, at this point, the law on whether or not Judge Murphy was right or not is all up at the fourth, and it stayed. We can't determine that in a stayed case. It stayed.
You can't go to the state and decide what this applies to?
I just argued what I have to argue, Judge. You're saying it stayed for only one purpose, but not. The answer is we are stayed and unable to do so.
You don't even know what evidence you ordered.
No, I believe we do, and I think that's.
But they want the defense to respect.
Need better internet than 5G? Your search is over. Get Cox Internet for just $4.
Now's the time to hit that like, hit that subscribe. Y'all rocking with the best and most valuable podcast this morning. If you're on your way to work, if you're on your way to school, if you're on your way to your little just know you're rocking with the best. Hit that like, hit that subscribe, hit that bell notification so you can get all notifications when we go live. And yeah, man, be part of this gang. Because if you gang, we same thing. You feel me?
You have a UTI.
No, you don't. No, you don't.
We do. I think that's on appeal at the fourth. But during a stayed case, we cannot do those things. And that's why it hasn't been done. Not because we haven't wanted to. They appealed it. It stayed.
Unfortunately, to also remind the court, the defense did cross appeal, so even stuff that would remain in is also potentially could now be excluded should the fourth rule in the defendant's favor.
And that's still pending before the fourth.
But you don't agree with their request. You want to go forward.
That's what he said.
Sounds like Melly does not want any more delays. He wants to try to go forward. He doesn't give a shit about anything anymore.
Just 5 minutes. It would take more than 5 minutes, but it can be done easily.
Well, again, and Judge Murphy did this not longer than me, but that's what he ordered you to do, 568 days.
Which,
That's what he ordered you to do. He didn't ask you to do. He ordered you to.
Damn. Both didn't follow instructions from Judge Murphy 568 days ago.
But he didn't do that.
And I'll tell
I
you
don't have the benefit of sitting next to him when he went through all of this, so that's why he ordered you all to.
And all we would be doing is reciting his order, quite candidly.
Who's arguing it before? That's what I was looking to do today. Who's arguing it? So what their question is, what evidence are we talking?
Everything from this date to that date.
What date is that? I don't know what all the exhibits are. How would I know that? You all know that. I don't know that.
That is part of the problem that we haven't even gotten to some of the motions. When we're talking about over 2 million Instagram lines, nothing is delineated that I am suppressing line 1,287,000.
You hear these statements, bro? This is what happens when the state pulls Instagram files and they have to hand over everything, and it's like millions of pages and shit.
Which I have a pending motion that's been pending now for well over a year, probably over 2 years now, or we're approaching that. And that is for the state to delineate what they are intending on using, because if they have 2 million lines of Instagram messages.
If it's been well over 2 years, how are you guys having deliberated, whatever the fuck word you use, how you guys ain't did that in 2 years? 2 years? You slow motherfuckers, it take y'all that long? What are y'all doing out there? Come on, bruh. Florida ain't no murder capital or no shit like that, bruh. I ain't talking down on my Florida brothers. I got some good souls out there. But damn, it don't take this long, bruh. This smells like a setup. This smell like a setup. Whether he did it or not, they don't have their cards in the right places. They can't prove what they trying to prove, so they trying to set them up. That's what the government does. That's what they do. The judicial system, that's what they do. They set niggas up. When they want you bad enough, when they feel like they have to win this case, they set you up. They talk to the judge disrespectfully. They low blow him. They catch him outside the courtroom like, yeah, nigga, we know you was at the strip club last Tuesday. You don't want this to get out. You better accept some of our motions. They do them like that, man. This is the shit that they do. These motherfuckers play dirty. They do. And see, they feel like they're dealing with criminals, so they have to stoop down to a certain level when they don't. You're supposed to uphold the law, right? The law supposed to be the all in all, right? Right up under God, right? Whatever you guys saying, right? So if you guys got this shit ironclad, stick to it. Why are you playing dirty? Stick to your ironclad shit. That's what you made it for. Y'all let me know if I'm tripping in the comments.
We can't be prepared for that. Are they introducing all 2 million? Are they introducing just some? And Miss Buckaloo.
Bro, I'm gonna zoom in on the judge's face there. He is so annoyed right now.
Let's not hear that motion. We're not ready for it yet because we don't know exactly what we're trying to introduce. So we have not had that heard. So I do not know what specific line the state wants to introduce that would be suppressed by that order because they have not told us. So all I'm left with is that sole period of time. I have nothing else I can say. I can say every Instagram from such and such a date to this date because I do not know what they're intending on using.
I do find this case to be under the most compelling circumstances. Mr. Devins, as I sit here today, has been in custody for 2,339 days.
It sounds like he's gonna vacate the stay.
Besides Mr. Devins' cases, which I've removed, this division currently has 38 other cases, special set for trial. 22 of those are murder cases. Numerous of those are death penalty cases. And right now, this division has trial special set through December of 2026. Which means any new trial dates I give out will be starting in 2027.
Did you just hear that? He said if he were to delay this September trial, the trial wouldn't be able to start until 2027. There's actually no way that happens. He's not going to do that.
Another year and a half. That's crazy. That's what I'm saying.
What drives an entrepreneur to...
The delays that these people be coming up with is crazy. Listen, I know the court is busy and all that, but like, goddamn, bruh. Y'all can't squeeze a nigga in or something? You want me that bad? Squeeze me in, bruh. Pause.
Oh, he just said he's already marked off the entire month of September and October for the...
So the defense doesn't object or the state's objection. The argument on September 10th. The state's motion to reconsider oral order moving forward with September 10th, 2025 trial dates can be denied.
Boom. Trial's not getting delayed. He's saying it starts September 10th. Thank God. I want this shit over with, bro.
Yeah.
What did he just say? Let me see if I can read his lips.
9 o'clock to 12 noon. Again, the only thing that would interfere with those is if
dude.
the trial is started tomorrow. And then have September the 5th.
Bro is not happy today. He don't want no more delays. He's snapping at his family, I think. So he just told them we have 20 hours of court before the trial starts, where we have to handle all motions and everything before the trial starts.
For a testimony as it relates to this homicide case, but we're going to go into another area, and that's where we'd be seeking that protection with the in-camera review of the open investigation. Well, they proffered some of them, and I understand what it's like to do defense attorney. I kind of know where they're going to go, Judge.
Okay, that question
So the court just declared you're refusing an in-camera hearing for the open investigation. The fact that it's an open investigation.
You want to bring a witness in the jury room outside the presence of the public?
Yes. With a court reporter. This is the guidelines that are outlined in Rule 332L. So the court is aware to create a record that there's an open investigation.
They're trying their hardest to give the judge details on why they think it's an open investigation still, and an in-camera review, but the judge's like, no, we don't have to do that.
I can show you the investigation record without your opinion. And that's the point of why I'm asking, just for purposes of the record.
You're telling me this could be ad infinitum. This could be for any
I can discuss that with the court in camera. The investigation's going to take. I'm not prepared to do it in front of.
No, but our person gets to decide if that's your position.
Well, it's also dictated by when and how evidence is received, where it leads, how long it takes to get that information, how long it takes to interview those witnesses, etc., etc.
Just don't want to tell us.
Are you kidding me? You could circumvent the globe. That request is. I mean, this is your making some more.
I don't know.
Judge say, nigga, you could fly around the globe in 18 months. Fuck is you doing, bitch?
So like, say attorney will sign a name and say, this person has personal knowledge about this case, right?
Yes.
Okay. So the rules are the same here in any other circuit or county court.
Shooting him down. She's a witness. She got to answer all questions at a deposition. Thank God the judge put his foot down. Can you imagine if this judge just delayed the trial to 2027? Hit subscribe. Love you, boys. Peace out.
Hey, man, y'all heard it first here, man. Shout out to my boy Cuff Boy, man. Hey, pray for Melly, y'all. Pray for that boy Melly. But it's your boy Cinco Bandit, man. You rocking with the most valuable podcast. I fuck with y'all like y'all fuck with